Welcome to The Explainer. Today we're unpacking something absolutely crucial, the ethical and legal significance of confidentiality in clinical practice. It's so much more than just red tape or checking boxes on an intake form. It is literally the invisible glue holding the entire healthcare system together. Let's dive in and see exactly why keeping a secret is a clinician's most vital duty.
Here's our roadmap for today. We're going to cover 1. The foundation of trust, 2. The 4 ethical pillars, 3. The modern legal framework, 4. When to legally disclose, and finally 5. The 8 principles of confidentiality.
All right, Section 1, the foundation of trust. Before we get bogged down in complex laws, we really have to look at the human element. The General Medical Council makes it super clear. Trust is the essential part of the doctor-patient relationship. Just think about it. If you thought your highly personal medical info was going to be gossiped about, what would you do? You'd probably avoid going to the doctor, right? Or maybe you'd hold back on your symptoms. And without accurate info, the clinical team can't provide safe care. So protecting data isn't just a privacy issue, it's a massive patient safety issue.
And this is definitely not a new concept. The whole idea goes way back to antiquity. The Hippocratic Oath itself explicitly says the physician must remain silent about what they see and hear, holding such things to be unutterable. That ancient promise is basically the bedrock of all modern medical ethics.
Now get this, because this is fascinating. That obligation is so profound it actually outlasts the patient's own life. The GMC guidelines are crystal clear here. The duty of confidentiality does not end with death. So even after someone passes away, the clinical team is still totally bound to protect their information. It's a lifelong and literally post-life commitment to a person's dignity.
Moving on to Section 2, the 4 ethical pillars. So, we know confidentiality feels emotionally and historically right, but how do ethicists actually justify it? Well, there are 4 common ethical theories here. First up, the implied promise. When you walk into a clinic, there's just an unwritten contract that your secrets are safe. Second is autonomy, which is your fundamental right to control your own body and personal info. Then we have virtue ethics and consequentialism. Let's zoom in and contrast those last two, because that's where the real ethical debates happen. Virtue ethics is all about moral character. It argues that keeping a secret is just what a good, virtuous professional does. Consequentialism, on the other hand, is all about the outcomes. It weighs the harms against the benefits. So, under consequentialism, you maintain confidentiality because the massive benefit of a trusting society totally outweighs whatever consequences might come from breaking that trust.
Okay, Section 3, the modern legal framework.
Those ethical pillars are fantastic in theory, but how do we actually enforce them in the real world? The really interesting dynamic here is that while the ethical reasons, like autonomy and trust, haven't changed in thousands of years, the law is constantly evolving. Basically, the legal framework gives real teeth to our moral responsibilities.
Today, clinicians have to navigate what's basically a legal triad. First, you've got the common law duty of confidentiality, built up from years of court cases. Second is the Human Rights Act, 1998, specifically Article 8, which guarantees your right to a private life. And third, modern legislation like the Data Protection Act 2018, which strictly controls how personal data is processed, stored, and shared. This creates a wild dual reality for healthcare workers right now. In one hand, you've got the gavel of traditional common law telling you to keep quiet. And in the other hand, you've got a keyboard hooked up to global data systems, meaning you have to follow strict digital protocols like GDPR. It's a constant balancing act between ancient principles and modern cybersecurity.
Section 4. When to legally disclose.
Now, what happens when keeping a secret is actually dangerous? This is definitely the hardest part of clinical practice. Ask yourself, under what exact circumstances is a doctor legally allowed or even forced to break that sacred trust and share your private info? It's an incredibly high bar, but the law does give us specific pathways.
The easiest pathway is for sure the patient's own consent. Now, this can be explicit consent, like signing a form voluntarily. Actually, scratch that, it doesn't even have to be explicit. It can also be implied consent. Like when you tell a doctor your symptoms, it's heavily implied they're going to share that with the rest of your healthcare team, like a specialist or a nurse, just to be able to actively treat you.
Beyond just asking the patient, there are 2 other main pathways to legal disclosure. One is a statutory requirement. That's when a specific law actively demands the disclosure, like reporting certain infectious diseases. And the final one is public interest. This is the really tricky one, where a doctor literally has to weigh the individual's privacy against the safety of the general public.
The courts view this public interest defense incredibly strictly. In the famous case of W versus Egdell, Lord Bingham basically hit the nail on the head, stating that only the most compelling circumstances justify breaching confidentiality. We're talking about a real serious risk of physical harm to an identifiable person. A classic example is a patient who has a medical condition that makes it wildly unsafe for them to drive, but they absolutely refuse to stop driving. In an extreme case like that, the risk to people on the road justifies breaking the seal of trust.
Which brings us to Section 5, 8 Principles of Confidentiality. So how does a busy doctor actually keep all this straight on a chaotic Tuesday morning? Well, the General Medical Council lays out 8 core principles. And these aren't just polite suggestions. They are the absolute rules of engagement for handling data safely. Let's split them into 2 groups.
The first 4 are super defensive. Principle 1, use the absolute minimum necessary information. Anonymize it if you can. Principle 2, manage and protect that data from being lost or accessed improperly. Principle 3, be hyper-aware of your information governance responsibilities. And Principle 4, just comply with the law. Make sure you're totally satisfied you have a solid legal basis for whatever you're doing.
The last 4 principles are much more about patient interaction and autonomy. Principle 5, share relevant info for direct care unless the patient explicitly objects. Principle 6, if it's not for direct care, ask for explicit consent. Principle 7, tell patients about disclosures they might not expect, keep them in the loop. And Principle 8, support patients in accessing their own info. They have a legal right to see their health records.
But look, human error happens. Systems fail, so what happens when there's a breach? Well, this is where we get the ethical duty of candor. If a mistake is made, doctors have an absolute duty to be completely 100% honest with the patient about it, and immediately follow data protection policies to fix it. Cover-ups are just entirely unacceptable, both legally and ethically.
We've seen today how confidentiality is this incredibly delicate balance of ancient ethics, robust laws, and strict daily principles. It really is the ultimate bedrock of clinical trust. But I want to leave you with something to think about. As we move deeper into this age of artificial intelligence, wearable health tech, and massive global data sharing, how are these ancient duties going to adapt to redefine the future of your medical privacy? Something to ponder. Thanks for joining me on this explainer. Keep asking great questions, and I'll catch you next time.